Good evening, everybody. I'd just like to welcome you to this second of our Garden Court seminars on the implications of the illegal migration bill. Before I say too much more, I'll just wait for the people who are being admitted to the online room. But I can say things that are probably not important, such as my own name, Sonali, Naik, KC from Garden Court Chambers, head of the Immigration and Public Law, head of the Public Law team, member of the Immigration team. And introduce our various speakers for this evening. I know that there are many people attending online. It might take a little while for everybody to be led into the room, and so again, each person I'll introduce them in turn, but we have an array of Garden Court talent here today to talk to you about the implications of the bill, and we will be starting with Stephen Galliver-Andrew and Emma Fitzsimons talking about the impact of modern slavery, the provisions in relation to modern slavery. David Jones and then David Neal, our researcher at Garden Court Chambers, talking about the duty to remove and the certification as a safe country process. And finally, Greg O'Kelly talking about detention. But I'll just wait for people to still file in, because I think people are still coming in. If you haven't watched the first session that was held yesterday, which was chaired by Stephanie Harrison KC, featuring Irena Sabic, Adrian Berry and Nadia O'Mara, be useful to watch that. I wasn't able to attend yesterday, but I've watched it on playback, and they set the scene for the overview of the key provisions of the bill, and particularly those that just tearing up the Human Rights Convention protection and exposing the issue of what are supposedly safe and legal routes. I think it's just been posted into the chat, that the link to that webinar from yesterday. Just a couple of house rules about, if you have Q&A, please put them into the Q&A box, and we'll hopefully get to deal with those later on this afternoon. Just also, as you've seen, that this is being recorded, so I hope nobody has any objection to that for the purpose of what we'll be doing next in terms of keeping it as a resource for persons to go forwards. And then the final part of our webinar series is going to be tomorrow. Nicola Braganza KC chairing, Amanda Weston KC, Catherine Cronin, Kate Aubrey-Johnson and Ollie Percy, going to be particularly talking about the children's rights aspects of the bill. So without more, hopefully I'm now ready to introduce our first speaker, and that is Stephen Galliver-Andrew, who's going to talk about how the proposals, in particular in relation to modern slavery, operate alongside Part 5 of the Nationality and Borders Act 2022. Thank you.
Thank you, Sonali, and good afternoon to everyone. So I am going to talk briefly about the provisions and the interaction of the illegal migration bill with the Nationality and Borders Act with the illegal migration bill, and the two correlate with each other. So to begin with, if I can just move on to the next slide, please, the slide after. So first of all, I want to talk a little bit about what Part 5 of the Nationality and Borders Act is. Now, essentially what Part 5 is, what it does is it excludes certain people from modern slavery protections. It came into effect on the 31st of January, 2023, and it is retrospective. So anyone who's been waiting for a reasonable grounds decision over the past sort of year or so can fall within it and can be excluded from the NRM and from modern slavery protections. There's quite a lot in Part 5. It's probably worthy of its own session in and of itself, but I want to narrow it down to public order disqualification specifically, because that's what's relevant to today. So why are we looking at it? So we're looking at it for two reasons this evening. So first of all, in my view, it's directly related to the illegal migration bill. It foreshadows further exclusions which are to come, which Emma is going to talk about. And second, I think, in my view anyway, looking at it, Part 5 almost functions to circumvent existing protections. So it does give an insight into how the bill might operate when it becomes law. Also, how the bill is amended as it goes through Parliament may well be an outcome of challenges to Part 5, or how Part 5 is actually implemented in practice. So we can move on to the next slide, please. So as I say, this is very much an overview of public order disqualifications. So I want to talk briefly about how they work and what they involve. So essentially, we're looking at specifically Section 63 of the Nationality and Borders Act. And Section 63, subsection 1 bites where someone is deemed to either be a threat to public order, or B, is deemed to have claimed to be a victim of slavery or human trafficking in bad faith. I think it's important to look briefly at the composition of Section 63. And subsection 1 does preserve executive discretion. You know, Adrian was talking yesterday quite a lot about some of the provisions within the bill where some of that discretion is completely taken away. So at the moment, Section 63 does give some discretion. It does preserve some discretion. So what's useful here, I think, is to look at public order and bad faith in turn. So if I can move on to the next slide. So what is a threat to public order? Now, within Section 63, there is quite an extensive list of people or offences that would fall into a public order remit, where that would fall for disqualification on account of being a threat to public order. A lot of those are the sorts of offences that you would expect the government to introduce into an act like this. So a lot of them are terrorism-related offences. There are offences related to trafficking. There are also, obviously, if one is excluded from protection under the Refugee Convention under Article 1F, there's a presumption of a public order disqualification. What is relevant for our purposes this evening is Section 63, subsection 1F, foreign criminals. Now, foreign criminals for Section 63 takes its lead from Section 32 of the UK Borders Act 2007. So anyone who's been imprisoned for at least 12 months, or anyone who's been imprisoned for a specified offence, is deemed to be a threat to public order. Specified offences then in turn takes its lead from Section 72, subsection 4 of the Nationality, Immigration and Asylum Act 2002. And I won't go into detail, but the 2022 Act slightly amends the 2002 Act. So what's important here to recognise is that under Section 72, there is a provision for the Secretary of State to make an order by way of statutory instrument to define a particularly serious offence by statutory instrument, which is subject to limited scrutiny by Parliament. And it's important to keep that in mind. So we can move on to the next slide. So very quickly, I just think it's useful here to think about that 12-month threshold and think about who would fall within that threshold. Now, 12 months for a custodial sentence isn't an awful lot in the grand scheme of things. Remember that for a lot of people, there is a presumption of release halfway through their sentence. So, you know, the sentence that's imposed is not necessarily the sentence that is actually served. And looking at the sentencing guidelines, you can see the sorts of things that would attract the starting point of 12 months custody. So a typical middle ranking theft, category 3, so medium value goods or low value, but with additional harm to victims, significant additional harm. Starting point for that would be a 12-month sentence, which within Part 5 would mean that someone is a threat to public order. Affray. So again, the middle ranking section of a fray, which is a category 2 culpability B, which is basically where there is a threat of violence or use of violence, which is less serious, but not minimally serious, that causes medium harm. That again attracts a starting point of 12 months. And again, there are specified offences which could come in, could be created by statutory instrument that could widen that scope out even further. So the question on public order is this, and this is what I'll leave you with. Should people lose protections from modern slavery for this sort of level of offence? Should people be excluded from protections because they may well have gotten into a bar fight on a Friday night? I mean, it's not the nicest of things, but on the grand scheme of things, is that proportionate? So I can move on to the next slide. So I've talked about public order. I'm now going to talk about bad faith. Now, I am going to refer to the modern slavery statutory guidance. Now, bad faith bites when an individual has claimed to be a victim of modern slavery, where they have knowingly made a dishonest statement in relation to that claim to have been a victim of trafficking or modern slavery. Concerningly, the guidance suggests that someone would have been considered to have made a claim in bad faith if they didn't explicitly raise this with the relevant authorities or first responder after being asked about it. And obviously, I don't need to explain the significance of that. It's within the statutory guidance. A lot of people do not feel comfortable disclosing elements of modern slavery or trafficking at first instance. There are all sorts of reasons why someone may explicitly deny any incidences or issues relating to trafficking or modern slavery when they're first asked about it. The other issue to be concerned about in terms of, for our purposes, is where someone raises a claim of modern slavery at the late stages of the removals process. So again, that can be something that would mean that that person is deemed to have been referred into the NRM in bad faith, and that in and of itself could lead to a public order disqualification. So if I can move on to the next slide, I'm going to quickly whiz through the steps now. I've got a couple of clients who already have public order disqualifications. So I'm representing a few people. So I want to quickly whiz through what happens. So first of all, someone gets a reasonable grounds decision. After that, they get what's called a minded to apply notice. And the guidance says that that should come as soon as possible after a reasonable grounds decision has been made. The minded to apply notices I've seen give 10 days to make representations, and any requests to have additional time to make representations or gather evidence are just ignored. The notice is then considered by the competent authority. I think what's interesting here to point out is that at the moment, there's very limited guidance. So there's about 3 paragraphs that are dedicated to guiding this process about how and whether to apply a public order disqualification. So the first paragraph of the guidance says that it should be decided on a case-by-case basis, and it should be on an individual basis. The second paragraph says that there needs to be a balancing exercise that is done by the decision maker. So the decision maker needs to balance the need for modern slavery protections and specific support against the threat to public order. The final paragraph refers to objective evidence that can inform that decision. So that can include sentencing remarks, medical records, reporting data, etc. And to give an idea of the sort of decision-making processes that we've got at the moment, there's one individual I'm representing who has a conviction for cannabis cultivation, out of which his reasonable grounds decision was reached, and he now has a public order disqualification. So if I can move on again quickly to the next slide. So in terms of what it means to have a public order disqualification, it's pretty straightforward here. First of all, the decision should be taken within 30 days. But if someone does have a public order disqualification applied, then they are excluded from the NRM. They don't get any support, they don't get any benefits. they don't get protection from removal from the UK, they don't receive a conclusive grounds decision, no prospect of discretionary leave. Perhaps most concerningly, they don't have any accommodation, right to accommodation, or if they are accommodated in MSVCC accommodation, they then have to leave that accommodation. And from what I've seen, there's normally about 10 working days for that to happen. So they are quite quick timeframes. So if we can move on quickly to the next slide. So a few legal challenges, and I'm going to briefly touch on some of the points here, but I'm sure you can already see some of the issues that we are already having to deal with, which the illegal migration bill is likely to exacerbate. So within Part 5, there's no formal mechanism for reconsideration. Whether or not the competent authority will entertain additional representations remains to be seen, but it's a non-appealable decision. So the only remedy would be a public law challenge. It would be a challenge by judicial review. So the suggestion here is that maybe what we need to be doing is front-loading our NRM referrals. So before someone is referred into the NRM, we possibly need to make sure that we do have the corroborating evidence in place, that we do have proper, clear instructions, which is very difficult sometimes and counterintuitive. But I think the danger here is that someone could well be excluded on bad faith, especially if you've got someone who has urgent removal directions and they raise grounds that indicate that they may be a victim of trafficking or modern slavery. And again, this is quite important for arguing that balancing act. The obvious question here is whether or not this is compliant with Article 4 of the European Convention. And I think it's interesting here again to look at the sort of the framing of the legislation and think about how the bill tries to replicate this sort of structure. So on one hand, you could say that because the reasonable grounds process has been preserved, there is still a proactive duty, there is still an adherence to the proactive duty to investigate where there are indicators of trafficking or modern slavery. That is preserved. So it may well be in bad faith, arguably, but it's still there. But on the other side, you could argue that Article 4 is an absolute right. And should it be subject to a balancing exercise between modern slavery support and public order considerations? I think the issue of limited guidance is going to be a problem, certainly from the decisions I've seen. It's not the best decision making, shall we say. I think it's also worth noting that a lot of these public order, there's notices to exclude people. They seem to be being sent out on quite a sort of frivolous basis. A lot of people seem to be getting them. And what I think this means is that there's a massive increased workload for the competent authority. So first of all, they have to consider these matters and then they have to make the decisions on them. So we've already got flawed decision making, but then we've also got an increase in workload. And that increased workload is also guided by limited additional guidance. So the question here is that will this also impact on initial reasonable grounds decisions? And then there's wider issues, and I'm finally going to leave on this point before handing over to Emma. So obviously the point on accommodation is one which is potentially very serious. If people lose MSVCC support, then they're going to have to very quickly look for support under Section 95, Section 4, Schedule 10, and they're only going to have a limited amount of time to do that. And if these people are foreign national offenders, they may well have bail conditions, they may well have license conditions, and these are issues that are potentially going to arise very, very quickly, and they're going to require very, very prompt responses. So that's just a very brief overview of Part 5. I think it foreshadows what's going to come in the bill, and the bill also expands on some of those curtailments on protections from trafficking and modern slavery. And on that point, I will hand over to Emma.
Thanks very much, Steve. I'm just going to hand directly over to Emma Fitzsimons, who's going to speak on, as we can see, clauses 21 to 28 of the bill, from her particular expertise in her trafficking practice. Thank you.
Thanks, Sonali. If I can just move to the next slide. Thanks, Angela. So just leading on from what Steve has set out, the existing framework for people who find themselves being identified through the NRM has already come under a significant attack as a result of the Act passed last year. And what I'm proposing to do in the short time that we have is just to outline the additional weakening of the protections that are going to flow if this bill becomes an act as well. I should say that at the end of our presentation, we've provided the links to the resources that Steve and I have referred to. So you can follow the bill's passage through Parliament, and you can also see the explanatory notes to the bill and the ECHR memo. So the first thing I just wanted to flag was the stated intention of the bill. There's been a lot of discussion by the Secretary of State that the purpose of the bill is to actually attack smuggling and trafficking gangs, and in order to prevent and deter migration. You'll see that, oddly, in clause 1D, one of the ways that this government proposes to attack the criminal gangs is to disapply protections and entitlements for potential victims of trafficking. Both David and David Jones are going to come on to talk a little bit about the removal provisions in the bill, but just to flag, the trafficking provisions would equally apply to a person who's caught by the duty to remove provisions. So when we come to look at the next slide, we'll see that the bill does a number of things, but essentially what we're concerned with here are people who arrive in the UK without leave on or after the 7th of March 2023, who do not come directly to the United Kingdom, and for whom there are reasonable grounds to suspect that they have been trafficked. So it's a clear attack on both Article 4 and ECAP protections, because in order for the scope of these provisions to bite, a person actually must have a reasonable grounds decision. So if we move on then to the next slide, what does the bill actually do? So there are a number of clauses specifically relating to trafficking, but for our purposes today, I'm going to flag clause 21 and 28, because I think that's the most pertinent for this discussion. So the first clause, clause 21 of the bill, extends the scope of the public order disqualification, which Steve has spoke about, now to automatically include all potential victims of trafficking who have a positive reasonable grounds decision if the Secretary of State believes that they fall within clause 2.1. So if you have a potential victim of trafficking who comes within the removal provisions, there's an automatic public order disqualification under clause 21. There's only a specific carve out, and that's for potential victims who may be cooperating with an investigation or in criminal proceedings, and that's very tightly defined in the legislation at clause 21. You'll see there that there's also provision for clauses 22 and 27 to withdraw the duty to support those individuals during their recovery period. And there's also analogous provision made for Scotland and Northern Ireland. It's also worth pointing out that these provisions are going to be subject to a sunset clause. So you'll see that under clause 25, the provisions will expire automatically in 2 years unless either they're revived or suspended by way of regulations, and the power to make those regulations lies with the Secretary of State for the Home Department. And then the final clause, clause 28, expands the scope of persons who are liable to disqualification under the Nationality and Borders Act. So Steve explained that the public order disqualification is already extremely broadly drafted, that it covers terrorism, trafficking offences, and anybody who's liable to automatic deportation, so anyone with a 12-month sentence. But this clause would take that a step further and include non-conducive deports as well. So any offence which brings a person within any of the deportation powers means that a person may well now be liable to disqualification. So we're seeing a further strengthening of the powers available to the Secretary of State when it comes to removal. In terms of examining the compliance of the bill with the human rights norms that are set out both in the ECHR and ECAT, I think it's useful to think about this from the principle of legality, because the courts at some stage may well have to examine this statute by reference to what Parliament intended. And classically, the principle of legality as a principle of statutory interpretation requires the court to assess to what extent did Parliament actually confront the difficult question about whether or not provisions are lawful or not. And interestingly here, there's already been a signal by the Secretary of State that she's unable to make a statement of compatibility under the Human Rights Act. So she is not confident that this bill is in fact compliant with Article 4 of the ECHR. And during my research for this presentation, I believe, I could be corrected, but I think they've only ever used that 3 times. So usually when legislation passes through the House of Commons, there will always be a statement of compatibility, and it's only a very small handful of times in the past has the minister not been able to stand over the human rights compliance of a piece of legislation. In addition, and I'm sure it was raised yesterday by the speakers, a real concerning general provision in the bill is that it will provide that Section 3 duty does not apply, which of course, when it comes to looking at protections for victims of trafficking, will place the court at a significant impediment when it comes to reviewing the terms of Article 4 and also how we view ECAT through the prism of Article 4. In terms of the actual head-on collision with human rights norms, the government recognised in their memorandum that there are issues in terms of both the ECHR and ECAT. And obviously the key provisions that are likely to come into question are the Article 4 duty to identify victims of trafficking, the right to a remedy under Article 13, as well as unforeseen discriminatory impacts which may well arise as a result of how the bill operates in practice. When it comes to ECAT, there are also problems in terms of compliance with Article 10, duty to identify, Article 12, 13, support to victims, Article 14 as well in terms of their recovery periods, and particularly Article 26, which provides that victims of trafficking should be at least provided the possibility of non-punishment. And it's interesting to see that the Special Rapporteur on Trafficking, for example, has already said that deportation should be regarded as a punishment that falls within the ambit of Article 26. So it's likely that removal under these expedited arrangements would also fall within the scope of Article 26. And then finally, the other thing I think it's worth remembering on the next slide is that there's a case to be made as to the effectiveness of these provisions, and that's obviously a slightly different argument that we're used to dealing with as lawyers, but it's nonetheless important because it goes to whether or not these measures are actually required and whether or not they go back to meeting that aim of smashing the trafficking gangs, as the Secretary of State said. And I think, just to borrow some language I heard from Alistair Campbell on a podcast this week, he said it's rather unfortunate that there's been no Brexit dividend for the UK. In fact, what is happening is the UK is paying France to prevent channel crossings, and that's a clear consequence of leaving the Dublin system and not being part of the common asylum framework anymore with the rest of the European Union. It's also worth flagging that as of yet there's been no financial costing of the bill, so we don't know how much the taxpayer is said to save by reference to these provisions. But equally, we're also clearly aware, as is the government, that there's likely to be a significant amount of litigation risk with this bill. The government accepts on the face of the ECHR memorandum and the inability to sign the bill off that there is likely to be real serious issues in terms of compliance with the ECHR. And finally, nothing in those provisions, nothing in clauses 21 to 28, actually tackles criminal gangs who are said to profit from channel crossings. All of the provisions are focused on potential victims. And so again, we're seeing a complete disconnect between the stated aim of the measure and in fact what's actually happening in practice. So with that, that's all I want to say at this stage on the bill. Thanks very much. I'm going to hand over now to David.
Thank you very much, Emma. That was really enlightening in relation to challenges going forwards, and particularly on compatibility. So we can see where people who are in the room who are thinking about briefing as well as litigation, where that line of travel might go. And also thank you to Stephen for setting out that the relevance of Part 5 and how that will work. So just handing on now on to David Jones and then David Neal, who are both going to be speaking to the issue on the new duty to remove and safe country provisions. Thank you, David.
Thanks, Sonali. So I'll just be running through the provisions relating to removal and offering a few observations on the potential facility to challenge the inclusion of Albania in the safe country list. And it is in respect of that safe country list, in my estimation, that the most serious impact will be felt as a result of this bill. The provision to remove illegal entrants or those falling within the 4 conditions in clause 2 to other safe countries, i.e. third countries, is really a fairly ineffectual power in circumstances where we have no third country removal arrangements. That doesn't mean that it won't have profound adverse effects on those subjected to that process in terms of them being put in a position of limbo potentially indefinitely, but it is really in the context of the removal to country of origin that this new bill impacts so profoundly adversely. I'm just going to share some slides. Bear with me. And hopefully you can all see those. And we'll do it to a slideshow. Okay, so there's quite a lot to cover, but I'll endeavour to go through the slides briskly, and the slides will be available to you after the training session so that you can spend a little more time on them. And where relevant, I've flagged up with hyperlinks resources, in particular the memorandum that Emma's already made reference to, which is quite a useful resource. So in brief, the new removal provisions, which are essentially sections 2 through, or clause 2 through to 10 of the bill, create a blanket obligation on the Home Secretary to remove people who have entered the UK illegally and to deem inadmissible protection and human rights claims made by persons who are so removable. So the categories of person who are subject to this removal exercise, those illegals, which pretty much embraces everybody, are defined in clause 2 by reference to 4 qualifying conditions. And so those affected under condition 1, the definition relates to their status in terms of their immigration status. So anyone that's entered without leave, that needed it, without entry clearance, that required it, who's subject to a deport order, or who required an ETA but doesn't have one, or significantly, anyone who did enter with leave but has subsequently been deemed to have secured that leave by deception, will fall within under this umbrella. And that latter category is quite important because it really embraces all protection applicants, even those who engineer a lawful route into the United Kingdom. And so one will have heard various ministers talking about, encouraging lawful migration into the UK and there being lawful routes into the UK for protection applicants. But even those that have, if you like, obtained entry clearance as a visitor, for example, will still be subject to these provisions potentially if they disclose that their object always was to come here in order to claim asylum, because then the acquisition of that limited leave will have been leave granted in the context of deception. So it's a very encompassing set of provisions. So that's condition 1. Condition 2 sets the time marker. And so it will have retrospective effect if and when the bill comes in to effect, as it doubtless will, sadly. Those affected will be anyone who's sought asylum or protection on the human rights grounds or VOTs who presented themselves on or after the 7th of March 2023. And it will affect under condition 3 those who have not come directly from a country where their life and liberty was threatened for a refugee convention reason. Essentially, that's the umbrella term I'm using rather than the one that's used in the Act. So it's on the grounds of social group or nationality or race or so forth. And then condition 4, it's almost a repetition of condition 1, but if a person requires leave to enter and doesn't have it. Now, there are exceptions specified within the bill for unaccompanied asylum-seeking children, albeit that the exception for that category of person merely transforms from a mandatory obligation into a discretionary one, the facility to remove, and under clause 5.1 relinquishes that protection anyway, even if it's extended once that child attains majority. And Emma has spoken about victims of trafficking, as has Stephen. There's also a facility to make further regulations with regard to exceptions, but judging the approach of this government generally, I think there's fairly likely there won't be a great enthusiasm for extending the facility to accept people from this process. Now, what is the effect of persons subject to clause 2 with regard to the protection claims that they advance. Essentially, anyone who falls within clause 2, who makes a claim for protection, a human rights claim, claims to be a victim of trafficking, all of those claims will be disregarded for the purposes of removal. They won't affect the facility to remove, nor will an application for judicial review in respect of the removal exercise. That's not to say that issuing a judicial review won't prevent removal. It can do, subject to your obtaining interim relief, and we'll look at some of the remedies built into the bill against the removal exercise shortly. So essentially what happens is, in respect of a protection claim or a human rights claim made for those subject to removal under clause 2, is that those claims are deemed inadmissible, and they are consequently not appealable under section 82 of the 2002 Act. And the claims are defined for the purpose of clause 4 as those made on or after the 7th of March 2023, which have not been decided by the Secretary of State at the time the provision comes into force. And so if remarkably the Secretary of State has considered a protection claim that came in after the 7th of March, but before the provisions of the bill gain legal effect, that individual won't consequently be subject to this process, and they won't be subject to definition as an illegal entrant under the Act. So in terms of removal, the exercise itself, the obligation on the Secretary of State under clause 5 is to remove as soon as is reasonably practicable after entry, or as we mentioned before, after a child has obtained majority. Now, removal is to the standard destinations that are specified in the 1971 Act: country of nationality, embarkation, a place where a person subject to removal possesses a passport, or a place the Secretary of State has reason to believe that person will be admitted. And helpfully, for the Secretary of State's perspective, that will encompass Rwanda. Although we're confident, of course, and Sonali is here to speak to that, doubtless, that we shall defeat that exercise in due course. So the two mechanisms of removal I've alluded to already. There are two effective routes. One can either be removed back to your country of origin if you come from a safe country, and safe countries are defined by section 80AA of the 2002 Act, which is amended by clause 50 of the bill, and it includes all within that list all European member state, EU member states, as well as Iceland and Switzerland and so forth, and importantly, for our perspective, Albania, a controversial inclusion on any estimation. Nationals of section 80AA states can be removed either to the country of origin or to a third country. And this is important when we look at the mechanisms that are available for resisting removal as to the consequences of successfully objecting to removal back to the country of origin for a safe country national. For nationals who are not section 80AA safe country list nationals, they can only be removed to a third country. And it's that category of applicant that the expectation is they will sit languishing, doubtless, in lavish hotel accommodation, according to the Conservative Party, until such time as either there's a change of government and a change of legislation, or remarkably, some of our former EU partners decide that they want to cooperate and accept back asylum seekers, which seems fairly improbable. So the exceptions then, the way to resist removal, so built into the bill, there are effectively two routes. The first is to establish that that there are exceptional circumstances in respect of a safe country national, which mean that removal exercise to that jurisdiction of origin, in this case it's going to be Albania, that we're concerned with as litigators, that there are exceptional circumstances to why that removal exercise should not be affected. Now, the definition of exceptional circumstances, really the expectation is from the memorandum and from the way that the legislation is framed, that it's going to be, you're basically advancing a claim that it would be a breach of human rights to return you back to that destination country. The test However, if it's met, as I mentioned before, even if you're successful in challenging removal on the basis there are exceptional circumstances, and there is no appeal route to do that, it will be by way of judicial review, the Secretary of State could still deem your case inadmissible and seek to remove you to a third country. So one of the various countries the Albanian national travelled through in order to get to the United Kingdom in the first place. The second route to challenge removal is to contend, and this is under clauses 37 through to 48, as, by reference to that regime within that part of the bill, that there would either be serious irreversible harm as a consequence of your being subject to a removal exercise where your only remedy under this regime is a non-suspensive challenge, that you would face serious irreversible harm if you were compelled to pursue that route of challenge. Or in the alternative, there are factual mistakes made by the Secretary of State or her officers when deeming you subject to removal. The only factual circumstance one could think about that might do that is if you actually had leave to enter or entry clearance and they got it wrong, which is unlikely to be a very frequent circumstance. So far as serious irreversible harm is concerned, the Secretary of State gets to define what that is under the bill. She sets the framework for that. Currently, she's issued guidance in the context of other certification regimes as to what that means. She says serious indicates that harm must meet a minimum level of severity, and irreversible means the harm would have a permanent or very long-lasting effect. And she also says that both of those things must be satisfied in order for the threshold test to be met. And she also describes the kind of scenarios in which a person might meet that test. In the context of Article 8, for example, she speaks about a person being a sole carer for a seriously ill partner or child, or a person being the recipient of an order from a family court with regard to the care of a child, or where an individual is seriously ill and would not be able to access medical provision in the country to which removal is proposed. And additionally, she flags up in the context of kind of the access to justice principle that if an applicant presents with perhaps mental health issues, which means that their facility to pursue a challenge remotely from that alternate destination would prevent them actually being able to effectively raise a challenge, then that may be a barrier which would satisfy the threshold test. And the process, you have 7 days under the bill, as it's currently construed, to raise those submissions on serious irreversible harm or factual error. Any rejection and certification of those submissions will mean that there is no remedy under the appeal system, and judicial review will be your only option. But if the Secretary of State rejects but doesn't certify, then there is a limited right of appeal to the upper tribunal on that very narrow basis of, as specified, that one of the two exceptions operates, not on a broader basis that you're a refugee or that you're entitled to protection because your human rights would be breached generally. So just on those narrow aspects of the test within the bill. And then with regard to clause 6, Secretary of State describes the approach that she'll take to adding other countries to the safe country list. It's quite important to be familiar with those because they can be beneficial and maybe influential in terms of the challenges that people should be considering with regard to inclusion of Albania in that list in the first place, which is something that David's going to speak to a little further in due course. But what she flags up in particular within the memorandum, for example, is that she's obligated to have regard to the circumstance of the country and information from appropriate sources with regard to conditions in that country when making that assessment. And so, as I'll suggest shortly, one of the routes to challenge will be to look at the sources she's identified and appraised in making that judgment and consider the sustainability of the same. Clause 8, remarkable actually that the Secretary of State has finally arrived at a point, the government have finally arrived at a point where they're willing to embrace a generous interpretation of what a family member is. Tragically, they're doing it only in the context of enabling removal. Perhaps that's predictable, but you're a family member for the purpose of the bill. If you're a spouse, a partner, if you're a child, if you're a dependent adult relative, if you're a member of the household, remarkable generous interpretation. The consequence less generous. The consequence is essentially that if you are such a family member, you can be removed with the principal applicant, and any protection or human rights claim that you advance will be disregarded along with that of the principal applicants. You can be accepted very generously if you actually, as a dependent, have leave to enter or remain, or remarkable that they feel the need to express this, but if you're a British citizen or have a right of abode, apparently you won't be removed either. So that's, I suppose, given Windrush, we can't assume anything about this government's conduct, but yes, useful. And the Irish too, wonderfully, are also excluded from this draconian system. Clause 9 deals with access to sport. I'm going to brush over that because I'm conscious of time, but the notes are there for your assistance. I have, in an elaborate way and with great enthusiasm, had a good old look at what the government has said itself about the compliance of the removal provisions with its obligations under the Human Rights Act. Equally, unremarkably, practically every single provision within the removal section of the bill is acknowledged to be potentially incompatible with the Human Rights Act, at least probably a 50% plus chance of it being incompatible. Quite brilliantly, the Home Office has told us what it thinks the illegalities are likely to be in its own legislation. So well, they describe it as their illegal migration bill memorandum, which Emma referred to. I like to think of it as a beginner's guide to litigating the bill. So do treat that as a useful template for your preparation of challenges. Obviously, don't be deterred if Ceallaigh has decided that there may not be an arguable case. She has reassured us all that the rule of law will be protected because she's confident ultimately that nothing in this proposed legislation will breach our human rights obligations. But just in case she's wrong, as she pointed out at the weekend, nothing's off the table. If she loses, we can always leave the ECHR problem solved. So have a look at the memorandum. Emma's alluded to it. It's very beneficial. It's a useful source of understanding how the government is going to approach its defence of the bill and how you should approach your challenge. And I have just made some notes again on the various positions that the Home Office adopts in relation to different articles. Quite brilliantly, in relation to Article 8, for dependents, it says, well, removal of dependents is unlikely to breach because everyone's going together. And so family life will continue unaffected, regardless of where it is that we're sending you, or the age of the people we're sending, or their disabilities. As long as you're together, everything's groovy. Just on designation of Albania, then just leading into what David is going to talk about, I think that there is definitely a platform from which to launch a challenge to the inclusion of Albania on the safe list in the first place. But there are also suggestions here as to the kinds of arguments you can advance in order to establish an exceptional circumstance threshold is met, or potentially serious irreversible harm arguments can be founded on this. So I think the starting point is to recognise that there is established precedent for removing countries from these kind of safe country lists, and the case of JB Jamaica is a case in point, and it's a useful vehicle for formulating and constructing our own challenges to Albania's inclusion. I think a starting point, given that the Home Office say, well, when we're looking at inclusion on the safe country list, we're going to familiarise ourselves with all the country information. Well, we need to know what it is that they looked at in order to make that judgment. And then we need to challenge the adequacy of the sources they relied upon, highlight the fact that there is existing country guidance, which is capable of establishing protection entitlement at the moment in Albania in the context of blood feuds and victims of trafficking. And then identify, unfortunately, I've failed to include the rest of the text, but identify the circumstances which enable a decision maker to go behind existing country guidance, which is quite constrained. And the evidence that enables that has to be sufficient and persuasive. And adduce evidence of examples of allowed appeals, grants by the Home Office in comparable fact cases to those that your clients are concerned with. We are already in the process and working with a number of solicitors to collate successful past decisions and appeal grants in order to mount specific case challenges and the broader challenge to the whitelist or the safe country list. But I'm going to hand over to David now, because he's got a lot more to say about Albania and the ludicrousness of its inclusion on this safe country list.
Just before I hand over to David Neal, thank you, David Jones, just to remind that it's 6:20 and we do have 2 speakers, so I'm hoping that we will be able to run on very slightly, but also as a note to David Neal that we might have to slightly go short if you can. Thank you.
Sorry, thank you very much. So as we've just heard from David, the bill creates what I can only describe as a legal fiction that Albania is a safe country, and indeed provides for Albanian claims to be regarded as inadmissible, and permits essentially summary removal of Albanians to Albania. Now, the designation of Albania as a safe country is wholly wrong. On the basis of existing country guidance and country evidence, Albania is emphatically not a safe country, and we're going to look very briefly at why. So most Albanian claims are based on one of 2 things, either blood feud or human trafficking. There are other types of Albanian asylum claims, but these are the big 2. Blood feud predominantly affects men and boys. And the headline point here is the existing country guidance, EH Blood Feuds Albania from 2012, makes clear that there is not, in general, a sufficiency of protection against an active blood feud, particularly in the north, but not exclusively in the north. There's been a lot of internal migration from the north to Tirana and so on, so that the problem isn't restricted to the north. So on the basis of EH, there is not a sufficiency of protection. And on established principle, the Secretary of State needs to show strong grounds supported by cogent evidence to justify departing from an established country guidance. So the burden's on her. She has to show strong grounds supported by cogent evidence. For some years, however, Home Office Country Policy and Information Notes, or CPINs, have been arguing that Albanian blood feud claims are certifiable as clearly unfounded. And the most recent ones in September 2022, and then the new one that came out in January 2023, both argue that there are strong grounds supported by cogent evidence for departing from EH. Now, I reviewed the September 2022 CPIN at the time and frankly debunked it, and went through the Home Office's own sources and pointed out that the evidence they're relying on doesn't support their conclusions. They came out with a new one in January 2023, and I have also reviewed and debunked that one. So I'd refer you to the detailed reviews that I've done. I've provided the links there as part of the slides to the PDF on the MICLU website. If you want a text version, there's a text version also on the Garden Court website. But it's important to remember that, as highlighted in MB Ethiopia and MST Eritrea, CPINs are not evidence, they're not authoritative, they're just a statement of the Home Office's position. You've got to look at the country evidence they're based on, look critically at that evidence, and look at whether it actually supports the conclusions. Next slide, please. In relation to trafficking, there's 2 country guidance cases, TD and AD and AM and BM. And these basically set out a list of risk factors, which you can see here on the screen, which include things like support network, social status, economic standing, and mental health, which is a very, very big factor. Those cases apply to trafficked women and girls. And if you can tick enough of these boxes, if you can show enough risk factors, then that deals with risk of re-trafficking, sufficiency of protection, and internal relocation, and therefore you win your case. So that's the approach to trafficked women and girls on the country guidance. Those cases don't apply to boys, but there was very important research that came out in 2019 from Asylos and Asylum Research Centre that I wrote about at the time that showed that many similar factors apply to men and boys. Factors include poverty, low education, physical or mental disabilities, domestic violence or sexual abuse within the family, and a pre-existing blood feud. Now, pausing there, the vast majority of the Albanians I've worked with display some or all of these risk factors. They're normally from poor families, from remote areas. They've normally got a background of abuse within the family, no support network, and invariably severe PTSD and depression, which, as we all know, most asylum seekers have got. So, if you've got any Albanian asylum seeker who appears to be resilient and capable, that's usually because their solicitor hasn't yet done the work of getting the medico-legal report that would evidence that they're not resilient and capable. So basically, most trafficked boys and young men and most trafficked women and girls are going to fall into these risk categories. It's relatively, these cases are extremely winnable on the current law. Next slide, please. As part of its general crackdown on Albanians, the new CPINs that came out in December 2022 and then in February 2023 have asserted that men's and boys' claims can be certified, which is a significant departure from the previous CPIN. It's again completely wrong, completely unsupported by the country evidence. And again, I've provided links to my detailed reviews of those two CPINs, and I would urge you to look at those, and you're welcome to plagiarize them, copy paste them as much as you like when preparing submissions and skeleton arguments on Albanian cases, and indeed when preparing JR grounds to challenge certifications. And this will obviously be absolutely critical in the new bill. When I carry out these reviews, I normally only look at the Home Office's own sources, the country sources they're citing, as well as established country guidance and sources they've cited in previous CPINs. The reason for that is even if you haven't had a chance to make representations before a decision is taken, in a JR, you want to be able to argue that even on the Home Office's own evidence and its own sources, the decision is unlawful and doesn't stack up. So even if someone was unrepresented, they've been, under the existing law, they've been certified, or under the new bill, they've been held inadmissible, you'll be able to challenge it using the work that I've carried out in relation to the Home Office's country sources. I'd also note that even these CPINs don't assert that trafficked girls and women's claims can be certified. And so the designation of Albania as a safe country doesn't make sense even on their own country policy documents. Even if they were right that men and boys had adequate protection, which they're not, the same is clearly not the case for women and girls, even on their own case. I also note that these trafficking risks are not only relevant to people who've been trafficked, sometimes they're relevant to people who claimed asylum for another reason, for example, domestic violence in the family, but would be going back as a severely traumatized person with no support network, and would be vulnerable to trafficking due to being in a situation of destitution on return. So you shouldn't just assume that these risk factors are only relevant to someone who's actually been trafficked. Sometimes they're relevant to someone who hasn't been trafficked. Next slide, please. Another cross-cutting, really important point is internal relocation. If you look at AM and BM 186 to 187, it's accepted that traffickers can track down their victims in other parts of Albania through word of mouth, essentially, through family and community ties. And Stephanie Schwandner-Sievers, who was the expert in AM and BM, really reinforces that in what she says in the asylum-seekers report, where she says you can't live anonymously in Albania. People situate you based on your family and where you're from. You can't disappear. It's a small country. People can track you down easily through word of mouth in any part of the country. And that's not just my personal opinion. That's what was accepted in AM and BM. Something similar was accepted in BF, which is the country guidance case on gay men. And there's a bunch of other sources that confirm the same in relation to families in blood feud. It's easy to trace people in Albania through word of mouth. Some of those sources were cited in the September 2022 CPIN, are mysteriously missed from the January 2023 CPIN. I set all of this out in my review paper on the blood feud CPIN that I linked earlier. So the short answer is, if you have a sufficiently determined persecutor, you cannot avoid them by relocation in Albania. And that's a general cross-cutting point across all types of Albanian asylum claim. Again, to certify on the basis of internal relocation, or to assert that Albania is a generally safe country on that basis, is just completely spurious. This has necessarily been very much a whistle-stop tour, because we're short on time, and all of the details are set out in the papers that are on the MICLU website and the Garden Court website, provided the links to those. So please use those, copy paste them, plagiarize them as much as you want for your own submissions. I'm absolutely happy for you to do that. But the point is, Albania is not a safe country. We should be challenging these decisions, both pre and post the new bill. And we should be pushing back against this spurious presumption of safety. All right, thank you.
Thanks very much, David. That was really, really helpful. I'm sure the invitation to plagiarise will be gratefully received. Because of time, we're going to move straight on to Greg O'Kelly. He's going to talk about the outrageous detention powers in the bill. I noticed that we're all talking about it as if it's going to be passed. It hasn't yet been passed, and this is a really important time in terms of briefing and fighting. So please, let's remind ourselves of that. Thank you.
Thanks very much, Sonali, and thanks everyone who's spoken so far. I don't think I'm actually going to be that long because these provisions are actually straightforward enough. They're pretty brutal, but they're not actually terribly complicated. I think a really important point is what Sonali said, and I don't think we should be necessarily assuming these will go through, and I don't think we can take this lying down. It's hard to overstate what a power grab this is. I do remember what Lady Hale said in Kambadzi about the proposition of a government official deciding to lock someone up until another government official decides to let them out again. That's the level of power that the Secretary of State has now. But the introduction of these new powers would allow a substantial expansion of that, and a substantial limitation on the powers of the courts to intervene, probably beyond anything that's been seen in peacetime. I think everybody's looking at this from the point of view of people arriving on our shores and people who are facing removal. But really what you're talking about is something close to internment, something more akin to extraordinary powers that have been used in wartime previously. Can I ask you to go to the next slide, please? So I'm going to be quite straightforward in this. First of all, I want to have a look at the new provisions themselves, and secondly, set out some of the issues they raise. Next slide, please. So the provisions in summary. First of all, clause 11. There's only really 3 clauses that are relevant to detention. First of all, clause 11. And that creates these new powers of detention for those being removed or considered for removal under clause 2, which we've already heard about. Secondly, clause 12, which is intended to remove the power of the court to examine for itself whether detention has endured beyond a reasonable period. It also expressly permits detention where there's an obstacle to removal. It permits further detention for a potentially lengthy grace period. And then we have clause 13, which is directed primarily, obviously, at people who are being removed under section 2 or clause 2. And that completely prevents detention being challenged by judicial review or by bail applications in the first 28 days of detention under the new powers. Next slide, please. And the one after that. Thanks very much. So the new detention powers, the clause creates new powers of detention. So clause 11 creates for an immigration officer a new paragraph 16(2)(c) and 2(d) of Schedule 2 to the 1971 Act. And for the Secretary of State, an equivalent section 62(2)(a) and 2(b) of the Nationality, Immigration and Asylum Act 2002. And the power is to detain a person who could be removable under clause 2, pending consideration of whether they are removable or whether the duty that was spoken about earlier by David applies, or pending removal or release. It also creates an equivalent power to detain their family members. And again, as David noted, the Secretary of State's vision of the size of family is significantly larger when deciding who can be detained than it is than deciding who can get entry clearance. It also excludes where detention is under the new powers, the protections for unaccompanied minors in paragraph 18b, for detained families in section 147 of the Immigration and Asylum Act 1999. So you may recall from the 2014 Act, there were limitations on how long you could detain unaccompanied minors, up to a maximum of a week in 18b. And there's similar limitations in section 147 in the Immigration and Asylum Act 1999 for people, for families. And of course, for pregnant women as well under the Immigration Act 2016. Another thing that the new clause does is it removes the power to detain under paragraph 16(2), where the new powers are available. So somebody who isn't, anybody who could be detained under these new powers must be detained, because the Secretary of State will have no discretion as to which power to use. Next slide, please. So obviously, the new powers are pretty extraordinary. You might think all of these people could be detained already. And if you think that, you would be right. Almost by definition, all of these people are people who could already be detained under paragraph 16(2). So you have to ask, why is the Secretary of State introducing these new powers? And the answer appears to be specifically to remove the protections as the place of detention, and to remove the protections for children and for families and for pregnant women. So obviously, every time there's a draconian piece of legislation that's gone through Parliament, an effort has been made to limit the practice of immigration detention, which is a weird thing that happens in this country. It doesn't happen everywhere, by the way. You don't have to do this. Like, other countries around Europe don't do this, but it's something they do in the UK, and a lot of people have tried to limit it. This is the first time, certainly that I've seen a piece of legislation in the last 15 years that specifically tries to increase the powers of detention, specifically for groups already identified as vulnerable to detention. So the Secretary of State looked at the situation in respect of children and pregnant women and families, and thought, well, we need to make sure that the detention powers cover those guys. We don't want any unnecessary limitations there, which is extraordinary. So there's a real likelihood, in my view, of the detention of children and families in particular causing issues under Article 5. There's long histories of challenges in that context, for example, in respect of places of detention. So from one thing about Naik against Belgium, for example, as well as potentially Article 8 and conceivably Article 3. I mean, accommodation of children in unsuitable accommodation can certainly breach Article 8 if anyone remembers the Tarakel litigation. And certainly this could conceivably give rise to Article 3 issues as well, particularly if it endures for a long period. Of course, one of the key provisions of Clause 11 is to completely remove the limitations on length of detention for families in pre-departure accommodation. So essentially it's seeking potentially to place something like the Manston IRC crisis of last November on a statutory basis. Next slide, please. And again, thanks. Clause 12. Clause 12 is being introduced in the context of obviously this bill, which is supposed to stop an urgent crisis of migration, by which basically the same amount of asylum seekers as usual arrive, except by different means of transport. And what's being done in that context with this clause applies to all immigration detention. So it's being presented, obviously, overall as being a measure to deal with people arriving on boats in Kent. In reality, this applies to all immigration detention. If you are a software engineer on a Tier 2 visa and you overstay, the following provision will also apply to you. And it allows, by amendments to all currently existing immigration detention powers, for detention to endure for a period that's reasonably necessary in the opinion of the Secretary of State. So I looked at that and immediately thought they're trying to reverse the decision in A. And effectively that's right. So it allows the common law limitations on the detention of people to be subject to the Secretary of State's own view rather than the court examining the issue for itself. It allows detention to endure even where removal cannot be achieved for the time being. So you've got an obstacle to removal. For example, Gambia, no ETD system. There hasn't been an ETD system in years. They removed nobody who didn't leave voluntarily. Well, according to this, should it go through, and that could conceivably be lawful. It introduces a new power to detain while the Secretary of State makes arrangements for release. So again, in the opinion of the Secretary of State, and these changes at least are subject to protections for pregnant women. Next slide, please. So what the point of the new powers seems to be is to place some of the hard-using provisions on a statutory footing. That's what the explanatory notes say expressly. It will remove the requirement that detention be for the purposes of removal. That seems to be deliberate. It removes possibly the requirement for diligence in pursuing removal. I've seen some analyses that suggest that's definitely the case. That's not definitely clear on the basis of the explanatory notes, and certainly if we end up in court, we'll argue that that's not right. But certainly on one reading, the Secretary of State no longer has to be pursuing removal diligently. The Secretary of State no longer has to be detaining for the purpose of removal. And in fact, if you think about it, the fact that they've introduced the power to detain while the Secretary of State decides whether to release you, where to release you, does suggest that detention no longer needs to be for the purposes of removal. Crucially, the court is the intention of the clause is to remove the court's ability to examine for itself if a reasonable period has been exceeded, and the intention there is the reverse decision in A. And the A, of course, wasn't unlike, according to the explanatory memorandum, it's A in following cases it seeks to reverse. Of course, there were earlier cases, such as Wasif and Mahmood, that reached the same conclusion. And you do have to ask yourself if this will work. Can the Secretary of State rationally detain somebody for a period that's not objectively unreasonable? Can the Secretary of State maintain detention on a belief that's not rational? Who knows? It's conceivable that the Secretary of State does have beliefs that aren't rational. I mean, I don't know if you've ever seen her on Newsnight, but it's certainly possible to reach that conclusion. Can the court decide whether the Secretary of State's belief is rational without examining the facts for itself? I would suggest not. I would suggest it will take some litigation, but there's a very strong possibility that we'll end up back with the Hardy-Singh provisions at least partly intact. Next slide, please. There is also a question mark of whether or not these provisions are compatible with Article 5. In Lumba, or Justice Dyson said, the Hardy-Singh provisions only do what Article 5 requires. When it was the position at that stage of common law protections against detention by a civil servant who's decided to lock you up were stronger than what was in Article 5. What's intended now by the Secretary of State appears to be to lower the bar in this country for what a civil servant can do to you before a court will interfere to below the protection that you get in Article 5. And of course, it did remind me of the case I did with Stephanie Harrison, 8 years ago at Fardus, where Secretary of State was seeking to argue that she could detain, that it was wrong for the court to be making these decisions for itself. And in that case, Lord Justice Thomas said, it's the objective approach of the court, which reviews the evidence available at the time that removes any question of the period of detention, can be viewed as arbitrary in terms of Article 5. And what does arbitrary detention mean? Well, arbitrary detention must mean detention that's only limited by whether the person locking you up thinks it's a good idea or not. And that essentially seems to be what this legislation is intending to put in place. Whether or not it succeeds is another question, that may be a question for all of us. It also seeks to place the grace period from AC Algeria on a statutory footing, expanded though, so that detention will be lawful again until the Secretary of State considers it to be appropriate. That's the Secretary of State has to decide that the release in question is appropriate, and effectively will have a power to detain until that point is reached. And again, without judicial scrutiny for as long as it takes, in the opinion of the Secretary of State. It's an extraordinary expansion of the Secretary of State's powers, and I'm surprised it hasn't reached more traction in the news. Next slide, please. So that's clause 12. Moving on to clause 13. Clause 13 is a much more benevolent clause, which just seeks to remove the power of the judicial review and bail for people who are detained. So the first thing it does is it introduces the power to grant bail for those detained under the new powers, both to the Secretary of State and to the FTT. Secondly, it makes the fact that removal under the new power is under consideration a relevant factor in a decision of the FTT as to whether to grant bail. So far, so good. Then it provides that where a person is detained under these new powers, they can't be granted bail at all until the end of the first 28 days of detention. And then they cannot challenge a decision to detain or to refuse bail in any court unless the Secretary of State acted in bad faith. Well, obviously, nobody could imagine the disgraced former Home Secretary and also current Home Secretary acting in bad faith, or in a procedurally defective way that amounts to a fundamental breach of the principles of justice. Also, a new innovation, public law errors can't render detention unlawful. So if she locks up Rishi Sunak without checking his ID, in principle, he can't do anything about it for 28 days at least. Although we have the comfort that habeas corpus is still available. Next slide, please. Difficult to see how habeas corpus provides any comfort, because habeas corpus is a remedy for illegal action. This is intended to make more or less all action illegal. So I don't really feel that that's any great support. The explanatory memorandum also claims the damages claims will still be possible. It was hard to see how that works, because they've explicitly got the provision in there saying that the detention isn't liable to be questioned or set aside in any court, which is actually kind of similar to the rules around criminal detention, which is why you can't bring false imprisonment claims in that context. So I don't see really how you can bring damages claim in that context, and I suspect the explanatory memorandum is not being entirely honest about what's trying to do there. It's seriously doubtful over whether these powers comply with Article 4, because 5.4, because obviously there's a provision there you need to be allowed to have your detention challenged speedily by a court and release ordered if detention isn't lawful. And this is designed specifically to exclude that. And of course, you have to remember the UNCRC comes into play here. Now, normally detention provisions, the UNCRC wouldn't come into play, but this is so widely drawn and is in fact specifically designed to affect children, and so it does. And every child has a right to have prompt legal access and appropriate assistance, and the right to challenge the legality of the deprivation of liberty before a court or other competent, independent and impartial authority, and a prompt decision on any such action. If they're detained for 28 days in circumstances where they can't do anything about it. 28 days is an extraordinary period of time in the life of a child. To suggest that a child detained would be unable even to apply for bail in those circumstances is absolutely extraordinary, even if there was an error of the law in the original underlying decision. But that's what the provisions are. Now, I know I've raced through it, but that's what the provisions are. And I think we will, sorry, next slide. And I think we will be dealing with them for some time. They're not cheery, but I suppose the way I've been thinking about it is at least we have something to do.
Thank you very much, Greg. That is not cheery, and we've got plenty to do. So thanks for those final words. Genuinely quite a shocking summary of some of the provisions in the bill, you know, following on from the seminar from yesterday. Anyone who's briefing really needs to be able to kind of interrogate those things that we've heard on powers to detain, you know, the relevance of habeas, on the conflict between powers to detain and human rights principles, the removal provisions on, but if it was a power, it would be bad enough, but it's a duty, as David Jones and David Neal set out, which makes life absolutely intolerable for the individual and for any lawyer trying to represent them and to seek a remedy, as well as the outrageous attack on the victims of modern slavery. So there isn't anything positive to say about the bill, except that it's not law yet, and we have got a lot of work to do in respect of that. I know we've run over time, so I'm just going to look at that one question that's in the Q&A, and if we have time to answer it. It says, would people who raise asylum arguments in their entry clearance applications fall under the deception provision if they then claimed asylum in the UK? Well, if you raise an asylum argument in your entry clearance application, you wouldn't get very far with that. So I think that's the answer, short answer to that. I'm not, unless there weren't any further, I don't think there are any further questions, and I know that we've run significantly over, but I really hope that people have felt the benefit of hearing the analysis that we've had this evening. I know that I have, and as I say, watch yesterday's recording and hopefully address tomorrow, if you can attend tomorrow's, or catch up with that on the child rights principles. And some of the things that Greg has and David particularly have identified about children are, again, truly shocking. And these provisions are impossibly draconian if they were passed. And I think the setup, as far as I can see, seems to be more of an intentional clash with the Human Rights Act and then the ECHR. That's some of them are so outrageous. The only purpose of them can be for that to trigger a departure from Council of Europe or some sort of other derogation from the Human Rights Act. So thank you very much, everybody, for your talks. Emma, Steve, David and Greg. Really fantastic and really critical for us all to get involved at the earliest possible stage. The bill has got its is in committee stage in the House of Commons, and we, I think, anticipate House of Lords committee stage towards the end of April. But the aim of this bill, as we know, was to push it through, not dispensing with the usual conventions, even of having 2 weeks before the second reading, and possibly in time to get in to appease voters in the early May elections. Let's see what we can do about that. Thank you very much.
Thanks, Sonali. Thanks, everybody.
Thanks.
Thanks everybody.